I just have a very brief comment that may not actually be useful or relevant, but here goes. It is interesting that in the first few patent acts, initially, if I recall, the first act opened it up to all persons, and then Congress amended that without much fanfare or any debate, simply to say only citizens could acquire patent rights. That may not make any difference as to whether they're natural or something else, but it's just something that may be of relevance.
I'm going to add it. Thank you.
Eric.
I thought it was a really interesting paper on a subject I did not think I would be interested in. And I asked this question with great fear and trepidation of publicly humiliating myself, because I know very little about patents, or nothing about patents, but I am curious about one part of this. So, Congress doesn't have to pass any law regarding patents, it seems to me. And if that's, and I'm not a big fan of the greater includes the lesser argument, but I am a big fan of judicial deference. It strikes me that absent violating another constitutional provision, and probably not, and I would not include in that non-structural federalism limits that, in my opinion, are made up by a lot of people. Congress can do anything it wants here, right? I mean, absent violating some other provision or defining patent in a way that is patently absurd, I guess this seems like a different type of constitutional provision and grant of power than most other grants of power. So I'm just wondering where that fits in to your desire to label. If Congress wanted to label this not a property right, why can't Congress do that? I guess is my question. And if it's a really dumb question, I apologize.
No, it's a good question.
Thank you.
Judd.
Yeah, so I'll start with like a small build-up point off of Eric's, which is why can't vested rights doctrines work differently in this context? Why do we sort of have to assume all of this stuff gets bundled into the same group? And the bigger question I have here is sort of what, and we've talked about this a little bit already, but what piece of this is originalist as opposed to what are you sort of pulling in that's more normative? I actually really like, I mean, maybe here I'm disagreeing with Christine a little bit. I think the original framework actually calls for a lot of normative judgments, and that seems to be an area where you and I agree, Richard. The point that sort of building on Eric's question, I would like a little more clarity on is under that original framework, who gets to make the decisions about what sort of natural law judgments are the right judgments. And I suspect that the answer for an original, somebody living at the founding is either a sort of legal judgment based on custom and tradition, or a non-legal judgment made in more of a utilitarian register by representatives of the people. And the conflation of those two things is what sort of makes me anxious. That is that you have the judges making the more normative utilitarian judgment. And I'm just very skeptical that that's the sort of thing that would have been happening at the founding based on my own work on free speech and Larry Kramer's work on judicial review and so on. So I'm kind of wondering about the who decides question. Even if the framework is right, how do we actually go about making these sorts of decisions institutionally?
Okay, let me sort of take the questions in order. It turns out the question, David, of whether you use the word person or citizen is one of enormous importance, but it's orthogonal to the issue that we have here. If you are working within a natural law framework, essentially there are no citizens because there is no state. And so everything that you give turns out to be to a person. And then what happens is territory comes into play. And now the issue is when you have these various kinds of natural rights like access to a river and so forth, are these to be given only to citizens within the polity? Or there's the same notion that everybody outside the state has the right to come in? This is, of course, exactly the kind of problem that you see in a case like Caulfield and Coriell, where they're kind of figuring out whether the outsiders to the particular state get in the same way. If you go look at the public trust doctrine cases that come up in the early 19th century, which are an extension from English law, they have the same kind of ambiguity. You look at the privileges and immunities clause, right? Privileges and immunities attached to citizens, due process and equal protection attached to person. And the clear notion is if you're a citizen, you get a set of smaller, more powerful rights, but the persons get a broader set of rights. How do you generally cash that out? Well, citizens are entitled to own property. The citizens are entitled to enter into occupations. Aliens are only entitled to the protection of the property they have, but they're not entitled to own property if they don't want to do it. They have to get a work permit. They don't have a natural right to do that within the system. That comes straight out of international law, uniform with respect to everywhere else, and it comes in here. So what they were really doing was sort of asking the question, do they want to open up their patent system to foreigners or not? And it's a kind of a more jingoistic situation to take the latter. Today, I think it's more the opposite. And if not, you could always have assignments to citizens in an effort to get around this. Now, the question that Eric asked is, I think, a very fair question. And let me answer it to you this way. The position that somebody had is if you make a grant in the standard term, it should not be understood as being implicitly defeasible at the whim of a sovereign. The argument's really very simple. What happens is we're asking people to commit an enormous amount of resources to invent stuff. And if we announce to them publicly that you have a grant which can be revoked at will, nobody's going to make those situations. So the uniform understanding on all of this stuff is if you don't put in those kinds of limitations, then what happens is you say there's a patent for 12 years. It turns out you mean exactly that. The patent is yours for 12 years. At that point, it becomes a 12-year grant like a lease or something else. And its revocation that comes out is going to be only on the terms at which other kinds of grants could be revoked. This then ties into separation of powers, which again is not a particularly English kind of concept. They did have enormous disputes as to whether these things were adjudicated at law or in equity and what was the relationship between them. But the basic separation of powers issues did not really become very, very clearly established until the 1850s. This is always part of the problem with respect to originalism. And I refer here to two kinds of cases. One is the unconstitutional conditions doctrine, which I think is inescapable whenever you're dealing with monopoly power, only is first asserted in the 1850s in connection with diversity jurisdiction, in which it is said that a corporation cannot be told by a state or an individual cannot be told by a state that if you want to do business within that jurisdiction, what you have to do is to give up access to federal courts under diversity jurisdiction. That was immediately regarded as an unconstitutional condition. And it's a kind of a tricky kind of originalist question because you're never sure whether they're saying this was always true as at the time it began or otherwise. When it comes to public rights, it's a very different history, but it's within the same period of time. And what happened is that when you started dealing with customs dispute, there was an informal evolution. First, you had a custom examiner, and then you disagree with that, and then you talk to his boss. And then after time, the boss became some kind of an independent tribunal, like a kind of informal court of equity. So when the Supreme Court got that case of Murray against Hoboken, this practice had been uniform in the federal government in the states for 35 years. And so they look at it and they say, hey, this thing does not match what we require about Article 3 jurisdictions, but we don't wish to upset established practices. So what they did is they carved out a public right exception to this stuff. And it was meant basically where the government was suing you in order to collect some patent duties that were otherwise owed. What Justice Thomas does is he completely misreads the history, completely misunderstands Crowell and Benson, insofar as it was an intermediate case, and then says that every time you get a statutory grant, you're going to be talking about a public right. But there's not a shred of evidence in any of the cases that they meant public right was created by statute, because if so, then the modern entire welfare state could simply get by Article 3 of the Constitution, and structurally we don't allow it. So what you have to do is then cabin the notion of a public right within some kind of a limited sort of situation. And so what happens is the answer to the combined answers to the last two questions are, look, you want to announce this thing that these things are worthless, you can do it. But the moment that you start to announce, in effect, that these things are granted rights, then they fold into all the traditional stuff as it applies to the question about what is a public right. You can't expand that category infinitely with the way in which Justice Thomas does. And it turns out you can't escape the doctrine of unconstitutional conditions in doing this by saying, we will only give you this right for 14 years if you agree that you're going to adjudicate it ex post in the state courts. There is just precedent after precedent in the federal system that separation of powers kicks in. So I don't know whether you think this is originalism or not originalism. The great problem with originalism is that it has to deal with many, many cases in which a practice is well established long before its constitutionality is challenged. And then you say, hey, this doesn't make any sense. And so, take the spending clause. Do you really have the power under the Maternity Act? No. But you couldn't challenge it by the time you got through with these cases. Interstate Commerce Clause creates an independent agency. Only Humphrey's executive 50 years later that starts to deal with it. Inheritance tax is clearly suspect, but in Magoon, they said these things have been around for 75 years. We're not going to mess with them now. Recent military courts, Justice Kagan said, I don't care what you say. We're not changing this stuff because we've been doing it for 50 years. The Electoral College and the fiction, forget about it. We've been doing this for the last 60 years. So this is just a major challenge to originalism. I think it's a valid challenge. And so the reason I keep it as patent originalism, I should add its uses and limitations, is I don't think that this story is just a story of historical evolution. I think it is a story about asking the question how much the original text properly executed binds subsequent generations.
Christine, over to you.
So this is a separate question, but I'm going to guess jump the queue through my commentator power. But Richard, this is a little bit of a fuzzy question, but I'm wondering if the fact that for a long time patents were registered and not granted through an application process makes them less property-y than something like land, in that because it was a registration system, someone could register a patent on all sorts of crazy nonsense that would be plainly unpatentable. And so the idea that it would be easier to say, oh, that was a mistake seems at least plausible compared to giving a piece of land which definitely exists to a person.
The land titles were often very scrambled. They're much more difficult than you think. A lot of them are Indian title, divided titles, and so forth. One of the things that intellectual property lawyers always make as a mistake is they think that land law is easy. And by the time you get done with it, point after point, there are real similarities. So the answer is no to that question. It's also, by the way, this is the thing that was decided, again, in a stupid compromise fashion in Ruckelshaus against Monsanto, where the question is whether or not when you had a trademark, right, was this a patent, or was this a protected name, or rather, in that case, it was an infanticide or rodenticide, or could they condition the grant on whatever conditions they see fit? And what Justice Blackmun says is these are clearly property rights, and he's right. And then he says there's no doctrine of unconstitutional condition. And so he has been roundly denounced for this, because what he says is you could register this thing, and then what we can do is take the information from your application and use it to approve somebody else's application, which is in conflict with yours, and that's not a taking. Nobody today believes that he was right when he said that. And it has been uniformly repudiated in all lower courts and all kinds of decisions. It's the same problem that took place in TAM. You want to register a trademark, that doesn't mean you forfeit it. All this, the registration system is designed to do is to give you greater confidence in validity, so that the ex ante stuff means that you can now have a presumption of validity in court. It doesn't mean that once you decide to register something, that it ceases to be a private right. TAM is very clear on that particular point. And Monsanto was clearly wrong on that point. But Justice Blackmun said, you don't like the conditions that we attack, then sell the thing overseas. You think that's a satisfactory answer and you can sell it overseas, no matter what he says? So it's not true. The unconstitutional conditions doctrine is a huge gloss on the use and abuse of monopoly power. And it's absolutely structurally required by the original Constitution, even though its articulations come only a couple of generations later.
I'm not sure all the patent and trademark analogies always are
I think
terribly well, given that trademark comes from the Commerce Clause and isn't designed to do the same kinds of things.
Use. They're common law rights.
To the extent there's federal protection from them, it comes from the Commerce
it's,
Clause instead of the Progress Clause.
But that doesn't matter.
But anyway, I want to make sure that everyone else gets a chance to ask questions.
Let's go to the next troika, which is Shakira Sanders, Chris Green, and Gary Lawson. Shakira.
Thank you. Thank you very much for this very interesting paper. And I want to pull a little bit, I think, from David Upton and someone else who had mentioned a subject around what I wanted to talk about, which is essentially the patent rights of slaves and freed African Americans and mixed African Americans in the United States. There's certainly a lot there that could enrich this topic, I think, by pulling from some of that. You have I think the early change in the law that required you to have citizenship status to own a patent. I think there may have been some concern there about the inventions that were created by slaves. Maybe there were people who were trying to get this patented on behalf of those slaves. But I want to point to, of course, the 1857 Dred Scott decision, which denied citizenship status to all African Americans, regardless of enslaved status. There was a year later, a U.S. attorney opinion that came out that said that was entitled Invention of Slaves or Invention of a Slaves. And the U.S. attorney there opined that because of Dred Scott, slaves could not own any of their works. And of course, it is the owner of the slave who truly owned the invention. I think there's a 2018 Syracuse Law Review article by Brian Fry with the same title, Invention of a Slave, that I think does some historical analysis of this. There is a Cara Swanson Columbia Law Review article from 2020 that does some other historical analysis on this. Many are citing to Justin Sumart's citing slavery article from 2020 as well. I think he may dip his toe in that. I'm still sort of reading that article myself. So I think there's a rich discussion that could be had here about ownership rights, the progress clause, but how does that all fit into a regime where not everyone could have ownership of the things they invent? And I've often wondered, how would that have been something that our framers thought, aided progress, that we would deny enslaved people their inventions, or was there no who cares, right, about these inventions? So I think there's a lot of effort to bring truth to light on some of this, and to quite possibly, if possible, get financial damages for stolen inventions of the past. And I think this piece could help shed light on, what were the views from an originalist piece, or even a more historical analysis on this. I think that also links to what people are talking about today in terms of the internet and what we've already seen as cultural appropriation on the internet of Black art, which many people think, these dances are dances patentable, right? That kids come up with, and what happens if someone gets famous off of your dance that you invented. So I think there's a lot of contemporary usefulness for a conversation like that as well. And I think it would just be, amazing to see a piece out of that focuses on that to some degree, and to add some richness to that conversation. So thank you for sort of giving me even just this idea of like, I wonder how this works in that context.
Chris Green.
Hi, so I'm curious how this interacts with the limited times bit and cases like Eldred. So I love the fact that Christina refers to this as the progress law, because it's not a power to give exclusive rights, it's a power to promote progress by means of the exclusive rights. And one thing that's really just, I guess I don't know if there's any way that people have proposed to do it differently. I mean, the fact that you get the same amount of time of exclusivity, no matter the subject matter, really seems like it's you're not going to get the same amount of progress for sure in different areas. And does that make any sense? To what extent does this original material suggest that we should be policing the connection between the amount of time and the exclusive right? And well, anyway, just that brief thing.
Fair question. I'll get to it.
Gary.
Dave? Who's next?
Yeah, I'm here.
Gary.
Yeah, just I'm on it. I had to unmute. This is really a footnote to something that Richard already said. It seems to me that the originalism aspect here has nothing to do with the grants of patents, but rather what happens after the patents are granted. And at that point, there are very serious original questions. Congress has a power, but not an obligation under the power to raise and support armies, to grant pensions to military veterans. Once it exercises that power and a veteran has collected a pension and has put the money in their mattress, what if there's something wrong, right? Well, the question is who decides whether there's something wrong and who can do anything about it? Does someone from the Secretary of War's office have the unilateral power to come in and say, okay, we think we made a mistake and take the money out of the mattress, or do you have to go to court to show the mistake? Same thing with the power to dispose of territory and other property belonging to the United States. Congress has no obligation to hand out the public lands. Once it does, there are going to be mistakes. And Richard is right, the early land titles were just god awful. The process was rife with fraud, with mistakes, with sloppiness, with terrible boundaries. There's all sorts of crap that's going to go on. So of course you need a mechanism for fixing the mistakes. The question is, does somebody from the Department of the Interior have the unilateral power to come in and do it? And the uniform answer was, of course not. If there's a mistake, you go to court and you show the court that there's a mistake and the court can fix the mistake. So the question is whether there's anything different about patents. Of course, Congress has no obligation to grant them, but once it does and you've got the patent, why is it any different from the money in the veteran's mattress or the potentially crappy land title that has been issued by the office? The question is not whether what you have is valid or not. The question is who within the government gets to decide whether it's valid.
Well, I'm going to answer Gary first because it's the shortest and the easiest question to answer. All of these cases, there's been a uniform procedure established from the beginning of time everywhere. That grants are finished when they're granted, and then to attack them for cause, it's a judicial determination. And in the patent office, it's not as though you do it unilaterally, so it's a bit of an overstatement, but you start looking at the processes that have developed within that court. They were, at least before the Trump administration fixed them up, they were travesties. Due process violations, right. The head of the court said, I don't like the outcome. I'm putting myself on another panel and we're going to reconsider what went on before. And so the due process stuff was an enormous violation of every common sense notion that you have had. Now, let me get back to the first two questions and so forth. One, the question with respect to the issue of how you deal with slavery. It turns out that my life as a Roman lawyer has made me, against my own will, something of an expert on the law of slavery as it starts to apply to various arrangements. And it's very clear to understand that when you're dealing with Roman slavery, it's a concept which applies not only to field hands who have no particular skills and so forth, but Roman slaves were essentially oftentimes highly sophisticated individuals who entered into very elaborate kinds of commercial transactions. And the standard rule with respect to this was that the owner could give the slave what they called a peculium, which then made him a limited liability trading company, so that anybody who dealt with the slave could bind the owner through the slave, but only to the extent of the peculium. And this later became the source of limited liability and corporations and so forth. It's also the case that anything that was acquired by the slave was necessarily owned by the owner, whether it was taken by occupation on the one hand or by way of stipulation. That is the standard contractual way of doing it. So that slaves were simply out from underneath the position. And so the shift from citizen to person or person to citizen has nothing to do with the slavery question. If you're a slave of a citizen, you don't have any rights. If you're a slave of a foreigner, you don't have any rights. it turns out that you're just wiped out under these circumstances. Now, the question about Dred Scott actually is also in part another Roman law question. It is very clear that under the Roman law doctrines, you could do something known as a mancipatio, which is a conveyance, only this was called an emancipatio, a conveyance out of. So it was a very unique kind of transaction. And what it said was, I'm going to convey you, but there's going to be no conveyee because it's not a transfer. And then you turn out to be a free person. It also turned out under Roman law that if you were a free person, you were not a citizen. It simply was an emancipation from what was going on. Citizenship had to come another way. What Dred Scott does makes a terrible mess of all of this, because the first half is mildly consistent with what Tawny wanted to say, i.e. Freeing somebody doesn't make him a citizen. But there's absolutely nothing whatsoever in the Roman law doctrine that says that a state cannot make a citizen out of somebody who is a former slave if it so chooses. And what really happens is that whole slavery question that gets tied up in the conflicts of law question between Illinois on the one hand and Missouri on the other, which is also mangled. So, I mean, what happens is, even if you know the doctrine of slavery, oddly enough, the traditional doctrines of slavery don't support Dred Scott. In fact, they go exactly in the opposite direction with respect to the decisive questions that we were trying to talk about. The real issue then becomes the conflict of law, whether Missouri dominates Illinois or vice versa and so forth. So, I mean, I think one has to be very, very careful. Denunciations of slavery are more than welcome under these circumstances. The question of that, how you do it, is not. The other question of cultural appropriation is a very different question. It's the issue of, is it a general tradition that you have an author, which is generally required under the statute. And the usual wisdom of that is if it's a customary evolution in which large numbers of indistinct people contribute different moves to this thing, nobody gets a patent, including a tribe who does this. If it turns out it's an individual, you can. If you're doing with various kinds of dances and so forth, there's another complication that comes up, which is many of these things are actually put out into the public domain with no intention to create any kind of intellectual property right. And once you do that, you can't then turn around and start to claim it after you've done it. So the patent equivalent to that is if I make something generally available to the public and everybody then can use it, I can't turn around and say, now that it's been used by everybody else and it turns out to be valuable, I'm going to patent that. So there are other restrictions I didn't talk about that deal with that kind of issue. Now, the last question, I guess, has to do with limited times and so forth. Eldred is a very interesting case because what happened is it's not a case where there was a patent which had an unlimited time. There was a patent. The patent was then expired. And then afterwards, a new patent was given. And the issue is whether or not some goods that have been made between the issuance of the first and second patent would be covered by the patent at that time. And my position was that the decision from Judge Marshall in this thing back in about 1813 riding circuit was wrong. Is that once something goes into the public domain, you cannot take it out of the public domain by saying, I'm going to give you a new patent. What you can do, in effect, is to say, maybe you can do this, but if you can, it's only for things, inventions that are made after the new notice has been given, not otherwise. The interesting feature about Justice Marshall is he used a very weak rational basis test, as we would call it, to give his decision. And it was that particular test that basically got Eldridge the way it did. I mean, I've written about Eldridge, and I think essentially once something goes into the public domain, whether it's land or intellectual property, you cannot reclaim it unilaterally. And so I think all those cases are wrong. I hope that answers your question, Chris.
Well, I just want to say I didn't mean Eldridge. I mean Eldred, the Larry Lessig copyright case.
I mispronounced it. I was talking about Eldred. It's a 2003 case that Larry Lessig argued.
Yeah, the copyright case. Anyway.
That's what I'm talking about.
For Eldred, yeah. So with Eldred, just, if you think that there's enough evidence that the original interpretation of the Constitution gave that preambulatory clause the power to limit the scope of the exclusive rights, then you get a very different result in Eldred, which was argued in the economist George Akerlof's amicus brief, where he was saying extending copyrights past a certain amount of time cannot promote the progress of science because it would be so irrational
Oh, yeah.
for someone to be more motivated to create something because their copyright would be, for example, 120 years instead of 100 years, that they're thinking about their great great grandchildren, that's so implausible that it would motivate anyone, that it is not going to promote the progress of science to extend the copyright any further, because the purpose is to motivate people.
Well,
So I
look,
think if you take that preamble seriously, rather not seriously, but if you take that preamble as having a limiting element, you're right, Chris, that you get some potential really different results, and potentially different results for different kinds of inventions and works.
okay, look, since the queue is short, let me sort of give a slightly more detailed answer than I gave before. There are two ways in which the promote language could be used. One with respect to the duration of the original grant, and second with the prospect associated with a renewal. And the arguments are very different. With respect to the original grant and so forth, the question is, can it be so long that we really don't care about it? And unlike patents, it turns out that the long tail and intellectual property matters. So if you go back to Eldred, it was Mickey Mouse and Company that were doing it. These were devices that were invented in 1932. The extension, by the time you know that they're valuable, was worth a bloody fortune. And so half the entertainment industry actually lined up behind this thing. And what they then said is, it's not only what we want to do in this country, it's also that we have to have these reciprocal treaties that we're going to make with Europe. They've given the extension that far. And in terms of the family stuff, the way in which it's defined is you get 50 years after the death of the author. So it's actually defined not in terms of commercial like a lease, but it's defined in terms of family interest. So all those guys made exactly that kind of an argument. And there's no question that as the time it's done, nobody knows whether it's true or false. But intellectual property has a unique feature that physical property doesn't have. It can get more valuable with time rather than less. I can't think of a single patent with respect to, a computer piece of software which works that. But with respect to literary stuff, it's the most common thing in the world that most of this stuff just dies off and is never seen again. But the stuff that's really valuable gets it. It's also, by the way, although you may not know it, this is also true of pharmaceutical drugs. A very good, reliable safety drug in its 12th year of patent life may have maximum sales because it's a better drug than it was the year it came out. Why is that? Because we now have longitudinal studies about the drug, which indicate both its effectiveness and its negative side effect. So people are much more willing to embrace that than a new product, where you have to do testing in a way that doesn't have this longitudinal feature that is associated with its operation. The other case is very much more powerful. It's that saying, look, if you've already made the damn thing, we're not giving you any incentive whatsoever if we now give you a free good. And so I made the argument in a piece that I wrote on public trust that this is giving away something for nothing. And you can't do that. So I regarded that as essentially beyond the power of the government. And the public trust arguments, religialism, a huge originalist tradition on public trust and private trust analogy. And that was the analogy. I said, anything you want to do with that and tangible property applies A to intellectual property and B applies to reversions. Okay, so I'll leave it at that.
Thanks. The next, I'm not sure what the duel of a troika is Jen Mascott and Will Baud. Jen.
Great. Thank you for the paper, Richard, which I found very interesting. I guess first, I just have a substantive question, whether you, in researching this, have found that the scope of things that we're giving patents for now match what the originalist understanding would be. So is some of the, for example, tendency to want to be able to strip patent rights more easily now because maybe the obviousness requirement is it as strict today as it would have been at the founding? Because you mentioned that people who are getting patents are actually giving over something in exchange. They're giving the instructions so that you can use their technology. And so I wonder if that meant that these incremental steps forward maybe weren't seen as patentable at the time. And then the second question is more of a practical one. If one is concerned generally, whether it's patents or other areas of like administrative agencies imposing penalties or whatever way in which they might be impacting vested rights, if one believes patents are vested rights. I mean, in your view, is there anything with this new court to be done to convince folks to revisit the public rights, private rights line, or does the oil states decision just mean almost everything's off the table and we're going to eventually by administrative agency allow almost, anything but the most core of private rights to be adjudicated with agencies. And do you think that the move, I mean, it seems like then the court's trying to, or the system's trying to counterbalance by giving some accountability then through perhaps through the appointments clause with the Arthrex challenge. Do you think that does any good by trying to bring other structural accountability mechanisms to play? Does that help? Or do we need to sort of, in a more vigorous way, try to get more rights protected by Article 3 courts than we have now?
So my question is just about reservations of rights. So when the government granted land, could it reserve some rights for itself? And if so, when the government grants a patent, can it reserve some rights to itself, or is it required to grant the whole kit and caboodle? And if the government can reserve some rights to itself, can it then use an administrative process to decide whether to exercise those rights? And can that get you, maybe not exactly inter partes review, but something like it? Because the government just says, at least going forward, the government will say at the beginning, this is not a complete grant, we're reserving rights.
Wow, that's a trick. Okay, let me answer the first question. Jen, the answer to the question actually is no and yes, simultaneously. What you're doing is kind of positing that there's a sort of a single direction in which the strength of patents and the non-obviousness or similar requirement goes. The history of patent law is exactly very, very different. And so there was some early period in which these things were extremely strong. And pretty much all the way through the 19th century, starting in something like about the 1940s or so forth, Justice Douglas got hold of this area and he just completely turned it upside down. So it turned out you needed to have a creative spark or a great leap of imagination to get a patent. And then it turned out that the definition of what counts as a natural law, or as opposed to an invention, was gave the natural law stuff a very, very broad definition. In a case involving Funk Brothers, where he said, if you figure out how you could put two various kinds of inconsistent chemicals into a single batch for making plants, that's a natural law as opposed to an experiment that you do. Then the 1952, Giles Rich and Federico, these two guys were told to draft a patent statute. And Giles Rich had written a very famous set of articles in the early part of the 1940s in which he denounced Justice Douglas as an evil genius and so forth. And he was generally accepted to have had the better of that argument. So by 1952, these two guys sitting in their kitchens drafted the 1952 Patent Act. And this was consciously designed to strengthen patent rights pretty much up and down the line. And it worked for a while. Rich then goes on to court in 1956. Federico dies at some point a little bit later. And then what we do is we have a very period of weak patents that take place through the 60s and 70s. And then starting in 1980, you get a strong period again. And then starting at around 2005, you get yourself a weak period again. And it turns out these are all positively correlated. If you're going to be weak with respect to the protection of what counts as a natural law, or you're going to be weak with respect to when you get an injunction and so forth. So all of this stuff is kind of within the ebb and flow of the situation. And it's extremely difficult, I think, to come up with some kind of a constitutional argument under these circumstances, which would say, no, you have to do it this other way. I do think that you can make a respectable constitutional argument that if you call something an exclusive right, you cannot, as a matter of course, deny injunctions. I think you could certainly limit them within the traditional framework. And how do you do it? Well, the rule is there were two ways. And what Justice Thomas did in the eBay case was he make a test up about the balancing test that you use for injunctions, which is very negative to it, which bears no relationship to the history whatsoever. And again, in the originalist approach that I'm advocating, you know how injunctions are to be qualified when you're dealing with land and other issues. Same point that Gary Lawson made about, well, can you do this here? And it bears no relationship to the test that they were prepared to put there. The modern cases like Alice and Mayo on the definition of what counts as a natural law bear no relationship to the historical stuff. They just simply expand the public domain beyond recognition. So I think that you have to say that. In terms of what can you do with respect to this, I mean, I'm actually very categorical about this. I think that the Patent Office can mess around with internal reviews in 1,000 ways before it makes a grant. And there were a series of procedures before these things were done where somebody could ask for a comprehensive review by raising a challenge. But once the thing was given, it was irrevocable. There were several statutes which said, well, you know, we'll have tiny little exceptions to this before oil state. They were never challenged constitutionally, which was a mistake. And so what then happens is Justice Breyer, who, as you know, is the champion of the administrative state, he comes and says, well, you know, you give an inch, you might as well give a mile. And so the mile is what it turns out that you get. I think this is a case in which there's no reason whatsoever not to have an extremely hard line. This then gets to Will's case about what it is that you can start to do with the grants with respect to patents. And it turns out there are two situations and they're treated completely differently. One of them is the situation where you're just simply applying for a grant based upon the fact that you've done the particular work. I am not aware of anything which says that the government can say, we'll give you this thing so long as you agree to the following kind of specific licensing terms, i.e. we get to use this stuff for free or something of that. I'm not aware of anything that would do that. I think, in fact, that it's a very difficult question because I think you're correct to say that if you don't have to give a patent, you can then be explicit and say, we're going to take this thing out of the patenting power. And that I don't think you could collaterally attack that. I do think that you could attack it after the grant is made and somebody says, well, now we want the government to get this kind of implied exception, so I can't do that. The area in which it turns out that these things actually do have genuine power is there's a famous book, oh God, what's his name? It's called Science, the End. Vannevar Bush wrote a book called Science is the Endless Frontier, in which he develops how it is that you're going to use government grants in order to make patents work in one form or another. So how many of you have heard of the Bayh-Dole Act, for example? Just give me a raise of hand. This is a constitutional law crowd, right? So I'm 0 for 37 or whatever the number is. But Bayh-Dole is a very interesting problem because what happens is if you make something with a government grant, the traditional form was that the government can say to you, you're using our particular money. The things that you make with our money belong in the public domain. And there's no question that this is now the question, can you attach that condition not to the grant of a patent, but to the grant of research support for the patent that the money comes out. And everybody believes that it's perfectly permissible for you to do so. But what Vannevar Bush said, and it turns out he was right, he says, what I'd like you to do when you get government money is to give us a non-exclusive license for free in quid pro quo for the exchange, but you could market it everywhere else. Nobody ever challenged that. The difficulty that people found is that if you put something into the public domain, nobody would develop it. And so the way in which this thing started to work is I give you a compound which may have some really strong therapeutic properties and so forth, and anybody can develop it. Each person is so worried about the fact that there are 10 other people doing the development on this particular product that nobody wants to put the money into this thing for fear that they're going to be preempted by this person. And so what happened is Bayh-Dole essentially is a command to commercialize. And so the way it works is the university that supports the patent grant is then in a position where it can say to individuals or to the university, if you want to patent this stuff, be my guest. You can do it any way that you want. And if you don't want to do it, then the individual investor can start to do this. And so what has happened under this is with this system of government grants, right? The commercialization that is, instead of putting things in the public domain, you're taking them out, right? Every university now has this huge resource establishment in which you first decide whether you want to share in the patent. And if you do it, you then have to figure out how you divide the take with the inventor. And then if you don't want to do it, the inventor gets it, but you have to figure out to what extent you could use university facilities and personnel and so forth to grant this. So these agencies essentially have become huge repositories of kind of a cultural wisdom on this. And there are hundreds and hundreds of millions of dollars that change hands because Bayh-Dole essentially started to initiate this stuff. So what happens is you see a kind of a very different phenomenon. The usual story that you hear is that, God, put something in the public domain, everybody can use it. That's true with respect to certain things, but if you're in the development stage and you have something as a compound in the public domain, nobody will actually start to do it for fear that everybody else is starting to do it. And so what they found is that the coordination game was crazy. There's a very different coordination game from the one in which Bout is developing chemical X for purpose Y and Mascot's developing chemical Z for purpose Y. Each of you is willing to live with the fact that somebody else is going to develop something which may be different in terms of what's going on. They will try to conceal that information from the rest of the world, but you know that if you drive up with a new cholesterol drug on day 1, somebody could take your market on day 2 because you can't patent the field. You can only patent your particular device for dealing with the field. Well, I will say for this in closing, if there's any other questions, I'm happy to take them. I just keep rambling on. Christina should answer. Is that if you actually understand how the patent system is put together, particularly by Federico and by Giles Rich, these guys were geniuses. I mean, there were just huge numbers of trade-offs that you have to make in terms of what you do with the patent and so forth. To answer your other question, Jen, there is also the situation where you ask about improvement patents, right? Well, it turns out new and improved was in the original statute. And the situation turns out then to be very complicated because if it turns out you make an improvement on your stuff, you patent it. Anybody can use the original thing without the improvement when that starts to expire, at least as a patent law. It turns out that is not true with respect to drugs that they have to be registered and you can remove them from the registry. And so the interaction between the patent system and the FDA system becomes very complicated through something known as the Orange Book, which is a real set of problems. But if somebody else makes an invention, they can sell it to you. And then you have the holdout problem as to how you kind of work these things out and so forth. All of this is within the stuff. The basic definitions of patent eligibility that you see today don't differ by more than 10%. What happens is a machine, when you were looking at it at one time, right, was a big old thing where you had a crank. Now a machine turns out to be a molecule of DNA, which opens up another molecule of DNA, right? And so that you can inspect it. And modern patent law essentially keeps all the same relationships, but it miniaturizes them by 6 orders of magnitude. Christina, do you disagree?
Christina, do you want to?
So I don't think this is, from an originalist perspective, I don't think this is a slam dunk because the things I'm going to cite are from the later 1800s. But I do think that there is historical evidence that cases like Mayo versus Prometheus have a historical basis, so which narrowed patentable subject matter from what it had been. So I wrote an amicus brief for the Cato Institute in that case, and so this is law office originalism at its best. But so the Patent Act of
that it's worst.
So the Patent Act of 1793 said you could patent a new and useful art, machine, manufacture, or composition of matter. In 1952, art was replaced with process, but they were intentionally the same meaning. It was just to clarify because art is used in so many other ways in the statute.
Yes, that's right.
So then it so there are not many treatises on or commentaries on American patent law. There's a nice quote that I didn't include in my comments from Justice Story saying that when he had to listen to his first patent case, he thought he would sweat through his, like if he wore a wig, he would have sweat through it because he had no idea what was going on. But some early treatises describe art as a process for producing an effect or result on matter. That's George Ticknor Curtis in 1867. And another one by William Robinson in 1890, and art is an act or series of acts performed by some physical agent upon some physical object. And so the idea of business method patents and algorithmic patents do seem like they, back then, still would have been outside the scope of a permissible patentable art or process. So I'm not, this is not, I'm not citing things from like 1800 here. So I'm not saying that this is a slam dunk, but I think it's more of an open question than it might have seemed from.
Well, that's another debate we have. David, I think, has a question still. Upham?
Yes, yeah, not very much a question, just 2 comments. The first, it's probably been discussed at length in the literature, but I don't remember running across it. And that is talking about the restraint of the preambulatory clause in that one. Probably a lot of interesting parallels could be drawn to the Second Amendment debates on that. To what extent does this limit the scope of the right or the right that is either preserved or granted?
One sentence answer, it limits it so you can't use a patent for importation.